Hello and welcome to Law Matters. My name is attorney Michael Conroy and I am your host as we explore various legal topics that impact the lives of many of us or our friends or families on a daily basis. I'm a partner in the law firm of Hassett and George, a general practice law firm with offices in Simsbury and Cromwell, serving all of Connecticut. This program is informational and is not a substitute for legal advice. Today's episode will be a discussion surrounding the probate court. The Connecticut probate court system is a system of 54 individual probate courts located throughout the state of Connecticut. The jurisdiction of each court extends to the legal affairs of the deceased, estates, some aspects of family law, conservatorship, and several other matters requiring specific legal decisions. As statutory courts, all jurisdiction and authority is governed by the state legislature. At some point, we all have an interaction with the probate court system. In this edition of Law Matters, we are focusing on the role and function of the probate court in Connecticut and how it may affect us. My guests today are probate judge Judge Elkin and attorney David Bondanza from the law firm of Hassett and George. Judge Elkin is a graduate of the University of Connecticut Law School and has previously served as an assistant state's attorney. He has also served as the corporation counsel for the town of West Hartford and has practiced law for over 30 years. Judge Elkin is also committed to the community and serves as president of the Probate Club of Greater Hartford. He is a past president of the Greater Hartford JCs and chairman of the West Hartford Zoning Board of Appeals. He also coaches boys soccer and baseball. Also with me is attorney Dave Bondanza from Hassett and George. Dave is a practicing attorney in the area of estate planning, probate, employment, and civil and commercial litigation. Dave routinely does estate planning and represents individuals before the probate court, and David lives in Canton. Gentlemen, thank you for joining me today.
You're welcome. Thanks, Mike.
Thank you.
Judge, thank you. It's nice to have you here. Explain for the viewers, if you would, what the nature of the probate court system is in Connecticut. People hear about probate court. They hear, I think the average person has heard the term probating a will. I think the average person has no idea what that means.
Well, the probate court covers a lot of different jurisdictions. As you mentioned in the introduction, it's the statutory court. We do what the legislature tells us to do. I think we figured out a couple of years ago we cover 63 different jurisdictions. The most popular or the most common, we deal with people's estates, trusts, conservatorships, commitments, adoptions. That's the best part of the probate system is adoptions. We do some children's matters, and then a whole smattering of other things that are somewhat related to those that I just mentioned. So we deal with people really almost from birth right through their middle years and when they pass. So it's a whole spectrum, and a lot of people come in contact with the probate court, and some people, depending on how they live and what their life is, may never come in contact with the probate court.
Let's talk about some of the more common matters that most people would find themselves perhaps in probate court over.
Well, the most, probably the one that they know the best is probating an estate, which is effectively, probating estate is to ensure the orderly transfer of wealth or possessions from one generation to the next generation. If people are fortunate enough to have a will, they direct how they want their material possessions to be divided. If they don't have a will, it's done by the legislature, and it's what's called an intestate estate. I don't recommend that for anybody. I recommend you have a will. It's your stuff, you collected it, you earned it, whatever, you decide how you want it to be devised and bequeathed. But that's how some people will come in contact with the probate court. Some people may, depending on what's involved, we've had a lot more adoptions in the last 10 years than ever before. A lot of people come into the probate court for adoptions. A very common thing is name changes. People, for some reason, need to change their name. Could be a pronunciation, could be for reasons that they don't like their name, or they were called another name from the time they were a child, and therefore they want to now make it official.
So, for example, if I want to change my name to Mr. Awesome, I have to appear before you or another probate court. And when Dave changes his name to Super Dave,
He would. Yeah. Well, I think Super Dave may be taken already.
Well, it may be trademarked. I'm not sure.
There you go.
Now, do name changes always come before the probate courts?
They could become. Well, we have concurrent jurisdiction with Superior Court, but I would say more often than not they're in probate court.
Great.
Let me ask you a question, going back to the estates for a minute. Some people, in my practice in doing estate planning, and I encounter a lot of people who come to update a will or take out their first will. One of the comments I consistently hear is that they want to avoid probate, and they treat it like it's a disease or something. Why is that? Is there really such a problem with going through the probate process?
I don't think so, but I think because there's been, you go back probably in the 60s, there was a book written by a gentleman from Hamden, Connecticut who said, How to Avoid Probate. And I think that stuck as a sort of a title. What people sometimes get confused about is that the probate court, well, they're going to, I might have to pay taxes, I might have to do, we don't have anything to do with the Department of Revenue Services. We don't collect taxes. The legislature sets our fees. It's a user court. If you don't use the probate court, you pay no fees. So they set the fees. They're very low, relatively speaking. And our job is to effectively oversee the orderly transfer, depending if you're talking about a estate, of what's directed, whatever the inventory is for the estate. And a lot of times people don't have to come to the probate court. They've made arrangements through estate planning that they don't need to. But there's always something may come up. I mean, it's just amazing some of the things. People will have this wonderful estate plan and they've followed their recommendations of their financial advisor, their attorney, and then they register the car as Mr. and Mrs. whatever, Smith. And now the surviving spouse says, I went to motor vehicle and they said I had to come to the probate court because I only own half the car. And the answer is that's correct.
Get a hacksaw.
No, if they had thought about it at the time and nobody asked the question,
right.
If they had said Mr. or Mrs. Smith, just to change the one little word and you don't have to come to the probate court. Well, you get people who come in for that. Sometimes there's unclaimed property for an estate nobody knew about. Not unusual occasionally where a bank or another type of financial institution will make a mistake entitling an account. And even though you've had the best plan made to avoid using the probate system, they still have to come back in. We try to make it easy and simplified. It's designed to be a system that doesn't need legal advice to go through. But there are some things that require legal advice. So I can't say to people, you shouldn't use an attorney. You don't necessarily have to for a lot of things. But when you start getting into tax issues and generation skipping trust and things like that, I don't recommend that the person do that without talking to their attorney or having an attorney to assist them.
Right. Now, even where someone who's passed on has engaged in proper estate planning and they've got a good plan in place, if there's a contest to that will, that would ordinarily go to the probate court as well, right?
That's where it would go. The way the statute is set up, all will matters, all trust matters are handled by the probate court. If an appeal should be taken, then it goes into Superior Court and the Appellate Court and the Supreme Court, as the case may be.
Now, you talked about proper estate planning. I've been involved in situations where the client will come to the office and they have a will that's different than the one that was submitted to probate. What's the resolution?
Well, it depends. If you notice, and as the public does, it's always the last will and testament, not which one. It's the last one, the closest to the date of death, I should say.
Not the one that's favorable to the client.
Well, it could be,
right.
But it's always the last one. That's the one that gets probated first. That's the one you would hear first. Now, people could object to it and say there's a reason it shouldn't be admitted, and you will go to the next one in time, and so on and so forth.
Are you seeing an increase in probate litigation where folks are contesting wills that have been submitted or codicils on a current basis?
I would say there's probably more over the last couple of years than I saw before, and some of that has to do with what I call lack of communication. The parents don't explain to the children what's going on. They don't have that conversation, and there's lots of good and bad reasons for it. And so a lot of times we get people coming in who object to something, not because they object for the legal reasons. They don't know. They don't know, why am I here? I got this notice to come to court. What's it about? Oh, I didn't know mom and dad had this. They never told me. And so a lot of times some of that litigation sort of dissipates once they get some information, have a chance to digest it. So but there is an uptick. There's no question about that.
Okay. I also noticed that, and correct me if I'm wrong, but there's a bright line in Connecticut of $40,000 on an estate being considered I don't know what the proper term of
Small estate.
Small estate or a large estate, if you will. The large estate takes significantly longer to resolve. Why is that?
Well, on the small estate statute, first of all, it's $40,000 of probate assets. For example, you could have a joint bank account with $200,000, spouse and spouse. It's not a probate asset.
Okay.
So, but let's say you have 2 automobiles and a small bank account, something under $40,000. The paperwork is somewhat similar, but because of the statute says you can move it through quicker, you don't have the time constraints that you would have with a regular estate.
Okay.
But a regular estate can move fairly quickly.
But what are those time constraints?
A will, according to statute, a will should be submitted within 30 days of date of death. A lot of times people do it, and a lot of times they don't even know there is a will because they may be looking for it. So we'll start with the submission of the will. Will gets submitted. If the estate is over $40,000, somebody gets appointed as the executor of the will, or if there's no will, it would be an administrator of an estate. Within 60 days of their appointment, they're supposed to file an inventory of the assets. Some people do it sooner. Some people don't get it in 60 days. Sometimes it's 90 days. And a lot of times it's good reasons. They can't find a lot of stuff. Again, it's a communication. If you leave information or you communicate with the people who you expect to be doing this, it's a lot easier for them. They're supposed to, a newspaper notice is published for creditors. They have 150 days to submit claims to the fiduciary, which you can translate into 5 months. Sometimes fiduciaries will submit it earlier than the 150 days. It's okay, they can do that. There's a little risk involved, but they can do that because a late claim may come in. They're supposed to file an estate tax return with the probate court. We don't collect any taxes on it. It's just an estate tax return, which has to be filed within 6 months, or there's some interest attributable to it. Most estates are under $2 million, so there's no tax anyway, but we have to get it. It's a Department of Revenue Services thing. We never figured out why it goes to the probate court, but it does. We review it, sign it, move it through. And once those are done, you can close an estate. You can file a final account and close an estate. So theoretically, I think the statutes anticipate less than a year. I tell people if you have the information, you can do it in less than 9 months. And again, it's to make sure that things are orderly transferred. Now, a fiduciary has the power, if they want to move things along, they can make transfers earlier. Most of the time they'll come to the judge for permission to do that, but they don't have to.
And that 9-month time frame is on a so-called larger estate, $40,000 not?
Yeah.
Okay.
It could be a multi-million-dollar estate.
Yeah.
It really is a matter of gathering up the information and processing it.
So how fast all the information is culled together so it can be processed through the system properly?
Right. I mean, there's a very good article in and I don't know if it's this month or last month's AARP magazine, which is our tips for people in thinking about their estate, and one of them is gather all your information together and tell the people who you want to take care of your estate where it is.
Always a good
Simplify. In other words, there's not a good reason in this day and age to have 6 bank accounts. Have
Sure.
one. If you're looking at 6 different banks, it gets to be, it's more work for the
Sure.
people who are left.
Well, you you mentioned a couple of things that routinely we hear about and see. Simplify things and put everything together. We have people that continually will put documents in a safe deposit box to which no one has access. And we often counsel them to avoid that, make sure there's either somebody that has access to it, or keep them at the house in a fireproof box or something that somebody can get to when they need them. For a healthcare representative or power of attorney or the like, it's difficult if they need those documents and they can't get them because it's a weekend and the bank's closed or something like that. The other thing you had mentioned was the estate planning aspect of this, and that it would help minimize the probate process. Okay? I know that in the 80s and 90s, it was very, very popular to go to an attorney and have a revocable trust made, and they call them living trusts. And you still see seminars now and then in the adult ed programs. My neighbor has a living trust, should I have one? Questions like that. But back then, the taxes on the estates, as you've mentioned, were $500,000. If you had more than $500,000, you started to get estate tax. Now, with the federal at 5.3 and the state at $2 million, is there anything other than avoiding probate that you run into in your experience that these revocable trusts provide people?
Well, I get the question every time I do a seminar. People say, I got this invitation to go to this dinner, lunch, seminar about living trusts. And I say, well, go and enjoy the meal. Listen to what they have to say. For some people, they are good things. If you happen to be an individual who owns an apartment in New Mexico, a timeshare in Idaho, a ski something in Vermont, a house in Connecticut, and a summer and a winter place in Florida, you might want to consider a trust to put the title of all the properties into one place rather than have to open an estate in 6 different states. So there might be a good reason. On the counter side of that is sometimes it's not a good reason, because when you put your principal residence into a trust, you lose the capital gains exemption that most people get when they sell their principal residence, because a trust is not considered a person for that purpose. It's an individual thing. You should definitely consult with your attorney or your financial planner. It's what's best for you. It's not, as you put it, it's not what it used to be. But, if for some people it works. For other people it doesn't. I've seen people make mistakes thinking that a living trust works the same way as a special needs trust when they have a son, daughter, niece, grandson, granddaughter who may have some disability and they want to put some money aside just in case, when they really need a special needs trust rather than just a living trust. So it's something you need to talk to professionals about, because everybody's got an individual situation.
Now that raises a related issue. When a probate court is administering a trust, and there's a third party, a trustee in charge of the trust corpus, and there's a complaint or a contest brought about by one of the beneficiaries, what are the options for proceeding if there's a beneficiary of a trust that at least is of the opinion that it's not being handled properly?
There's several statutes on it. There's the Fair Investor Act. There's requirement that a beneficiary can always ask for an accounting. We oversee it. If we find anything that's irregular in the accounting, we can order the fiduciary to replace the funds if it's irregular. If they're using a brokerage house that is creating a lot of brokerage fees by buying and selling a lot where it doesn't seem to be necessary. We can order that be terminated or money replaced. We do have the authority also to turn it over to the Chief State's Attorney's Office for criminal sanctions if in fact we believe that that's what's occurred. Doesn't mean they're going to pursue it when we turn it over to them. So it happens. Oh yeah, it happens. Beneficiaries sometimes are not happy what's going on, and a lot of the time it's because the trustee didn't properly communicate with the beneficiary. I have one now where I think it was like 16 years between communications.
Wow.
Just
Oh, wow.
and could have avoided a lot of now they're straightened. I don't think there was anything criminally improper. There may have been some trades that shouldn't have been done, but now the trustee's got to go through hoops at the trustee's expense to put all of this together when simply a yearly statement would have, or just a summary each year, but they didn't do it. And I'm not sure why.
Shifting a little bit, we in estate documents, we have documents known as a power of attorney. And from the court's perspective, there seems to be a related issue called a conservatorship. What's the difference between those two?
Well, power of attorney is a document where you appoint someone. Could be a relative, could be a friend, could be a financial person, could be a trusted individual, hopefully a trusted individual. It actually gives them the power to take over and do things that you give them authority to do, because power of attorney can be as simple as you can only do banking, nothing else, to you can do everything. And it's a very powerful document. Conservators are people appointed by the court, either through a voluntary conservatorship or an involuntary, that would step into the shoes and take away those rights of decision from the individual, and the individual would not be able to make any decisions. In a power of attorney, the individual still can make those decisions. They can overrule the power. They can revoke the power.
What about in a situation where an individual signed a durable power of attorney and they've subsequently become, tragically incapacitated? Who's minding the store, if you will, and preventing that person from potentially abusing that power?
Unfortunately, there is nobody minding the store unless it comes to the attention of the probate court. Then we can request an accounting, but it has to come to our attention.
Okay.
And a lot of times it does not until, unfortunately, something bad happens, and then it ends up in our doorstep, and we try to do what we can under the circumstances.
Okay. You mentioned a voluntary or an involuntary conservatorship and taking away the rights of an individual. Isn't the sort of the power of attorney equivalent insofar as powers go that the court might grant to, especially in a general power of attorney, to allow a person to act as the other?
Except with a power of attorney, there's no requirement to, in the case of a conservator of estate, there's a requirement that you account for the funds. Power of attorney doesn't necessarily have a requirement. Conservator person, you're required to report to the court how that individual is doing. You can't sell the person's possessions without court approval. You can't terminate a lease without court approval. You can't move them to a long-term care facility, for example, without approval. So there's a lot more safeguards in a conservatorship than there is with a power of attorney. As I say, it's a very powerful document and could be abused. That's why you have to be very careful that you appoint somebody you really trust to use it properly.
And in the case of apparent or believed abuse of a power of attorney, let's say an individual appoints a friend as their power of attorney, and then one of the individual's children feels that that power is being abused. That's the type of thing that the probate court would have jurisdiction over if it's properly brought to the court's attention.
If it's
right?
properly brought to the court, we would have jurisdiction over it.
Okay.
Generally, the first step would be to order an accounting, if it's involving finances,
Right.
Or a report if it doesn't involve finances. Tell us what's going on. Some people comply right away because, oh, it's a court. Other people don't.
And these types of issues can often result in full-blown litigation at the probate level.
Oh,
right?
absolutely.
And now the litigation in the probate court is a little different than our regular civil courts, is that right?
Much different.
But-
It's less formal. Less formal in the sense that you don't have, a judge doesn't wear robes. We don't sit up behind a big bench. We usually are at a table. We don't have marshals ordering people around. And the nice part is everybody gets to speak, just not at the same time, but everybody gets to speak.
Preferably.
We do operate, though, now. I think most of the judges operate now under the rules of evidence. But we try to be fair to those people who are not attorneys. And there's some attorneys who don't understand what the rules of evidence are also. But the rules of evidence, we try to operate under the rules of evidence, which can be very technical at times. But we try to make it fair so that we ultimately get to figure out what we need to get figured out.
And there's no jury system in the probate court.
Absolutely not.
So typically, if a matter has to be tried, are we looking at generally shorter time frames than the regular
Much
civil
shorter.
docket?
Yeah. I would say if you're in a civil docket, you could be 3 to 5 years. In the probate court, I would say if it's really, really contested and they had to do a lot of discovery, depositions, you're probably under a year.
That is pretty fast,
Usually is.
comparatively.
Now, you've been a judge for some 10 years. How are the judges for probate selected?
We're elected every 4 years, just as the same as the gubernatorial cycle. And this particular year happens to be an election year in November.
Where can we get more information on the probate court?
The probate has its own website, the Connecticut, it's ctprobate.gov. That will get you to the main menu. Then from there, if you need forms, you can click on a button for forms. If you want to know which probate court you go to, you can click on where the probate courts are, names of judges, lots of good information. If for any reason you somehow end up on the judicial website, which is okay, there's another button to push to get to the probate website. So, yeah, and it's a pretty easy website to work these days. I wouldn't say that 2.5 years ago, but I think now it's pretty much better than it used to be.
That's great. I appreciate it.
And
Well,
some of the probate courts, by the way, do have their own websites.
Oh, I didn't know.
Not all, but some do.
Well, Your Honor, if you're seeking re-election this fall, best of luck.
Thank you.
Thank you for being here, and thank you, David.
Thank you.
Appreciate it. That's all the time we have for this edition of Law Matters. Thank you for watching. We hope you found the show helpful and informative. We should mention that this program is intended for informational purposes and is not a substitute for legal advice regarding your particular situation. For more information on this program or other legal issues, please feel free to visit our website at www.hgesq.com.
Funding for Simsbury Community Television is provided in part by contributions from viewers like you. Thank you.